You brought a lawsuit against your careless doctor claiming that he caused you significant harm and injury. Your case goes through the entire litigation. Now you begin to negotiate. Why is it that the defense's initial offer, settlement offer, is a lowball offer? Do they ever think you're going to turn around and say, yes, okay, I'll take it? You want to know the answer? Come join me for a walk around the neighborhood, on the beach sort of, as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against your doctor claiming that he was careless and caused you significant injury. Now, the doctor turns around and says, I did nothing that was improper. I did nothing to cause you harm. And if I did, guess what? Your injuries really aren't that bad. The defense denies, and refuses to accept responsibility for what occurred to you. So you have no choice but to continue with your litigation. Now, after you notify the court that your case is technically ready for trial, and now the defense for the very first time calls your attorney and says, hey, would you be open to negotiating this case to try and settle it? And your attorney says, yes, of course. What's your offer? And now they go back and forth over the next couple of days or weeks, and the very first offer that the defense makes is a lowball offer, an insulting, disgusting offer that your attorney immediately rejects. So you may ask yourself, why during the course of negotiation would the defense offer something that is so low, that is so insulting, that now nobody in their right mind would ever accept? Why would they do that? I'll tell you why. It's because the defense has a different agenda than you and your attorney. Your attorney's goal is to obtain as much money as possible for you as a form of compensation for all of the losses and harms and damages that you suffered because of this doctor's carelessness. The defense, on the other hand, has a totally different agenda. Their agenda is to try and resolve this case for as little as possible, to save the insurance company and their principals as much money as possible. If they can do that, now they are in a better place. Why? Because they know that if they ultimately have to go to trial, they're going to spend a tremendous amount of money defending the case. They're going to outlay a great amount of money to pay their attorney. There's going to be additional fees with experts. The costs will go up dramatically. But I have to tell you something else that nobody talks about. The defense is willing to do that even if it means going ahead and spending hundreds of thousands of dollars. Why? Because these attorneys and these defendants, they will fight tooth and nail and invest whatever they have to if they believe that they are right and we are wrong. Which means, if there's an opportunity to go ahead and try and resolve this case that you reject, and now they turn around and say, okay, you don't think we can settle it for that number? Fine, we're going to go to trial. And your attorney comes back and says, listen, but you're going to have to spend X number of dollars in order to try this case. And you know what they say? That's perfectly fine. We'll go ahead and spend an extra $100,000, $200,000 just to show you that we are right. And now, when the jury comes back in our favor, guess what? We will have shown that we're right. And even if they don't, even if the jury comes back against us, we will go all the way, which means they're going to go ahead and appeal that decision. They're going to go ahead and appeal that verdict and exhaust every possible opportunity to go ahead and try and either reduce the verdict or get it thrown out ultimately. Don't think for a second that just because the defense is willing to negotiate with you, that automatically means they're throwing their hands up and they'll take out their checkbook and write you whatever they want. No, that's not how it works. Instead, when the defense comes back and says, listen, we'd like to negotiate, they are trying to see how low they can go where you will accept it, knowing that there are risks on both sides. You know, there's something else nobody really talks about. That's the risk of accepting an offer as well as the risk of going to trial. Nobody talks about that. Everybody talks about, okay, we got this great settlement. Okay, we got this great verdict and then settled the case afterwards. Those are all excellent things to talk about. But what nobody talks about is by accepting a settlement, there is a risk. And you might be thinking, what are you talking about? It's a guaranteed amount of money. And yes, it is. But sometimes the person who accepts the settlement may have regrets. That person may turn around, a week later, a month later, a year later and say, you know what? I should have stuck it out. I should have gone to trial. I should have done the following things. So that is a risk that can occur. But the reality is, when the defense makes an offer, their first offer is virtually always a lowball offer. And I asked that question at the very beginning. Why? Why would they go ahead and make such a lowball offer? Well, remember, I told you, their agenda is different. They want to try and settle this for as little as possible. But here's another key strategic negotiation strategy as to why they offer such a low amount at the beginning. They want to probe. They want to see where your attorney is going after such an offer. They want to see if he cuts off negotiations and says to them, listen, unless you're serious about trying to go ahead and settle this case, there's no point in even talking any further. If your attorney gives them an idea that, yes, we are interested in that range, now they know they've got you and your attorney on the hook, and guess what? Now they know they can definitely keep this number low, and that's to their benefit. On the other hand, there's another key strategic reason why they make a lowball offer. Say they offer $1 million to start, and your attorney says that's a lowball offer for this particular injury. In that instance, they can't turn around and say, you know what, we're going to withdraw that offer. I'm going to give you $500,000 instead, or $100,000 because you chose not to accept our offer. Okay? Those are different strategies that they use to try and understand where your attorney is going, where he thinks he needs to be. But if they didn't start low, they would not have the opportunity again to go back lower than what their initial offer was. So why do I share this quick information with you as I'm taking a walk along the beach here? I share it with you just to open your eyes as to how these cases are really negotiated and what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases in New York. I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.